You have floor privileges. Come down and visit us. We're always happy to see you. Our presentation today is from Dr. Tom Ricoeur. Beau Chastain has volunteered to introduce Dr. Ricoeur, which raises the issue of who is to introduce Beau Chastain. Apparently, he needs no introduction, and he's not going to get one from me. Beau, come ahead. It's just always heartwarming
About
to
that.
anyone else having difficulty with all this newfangled.
Thank you for not introducing me, Senator Bryan. But thank you to you and to Chairman Creekmore also for the invitation to come and present to y'all today to both of your committees. Dr. Tom Ricoeur, as you said, is here to tell you about the efforts that the Department of Mental Health is making to expand and to improve forensic service delivery in the state of Mississippi. And in working with Dr. Ricoeur for about the past 7 to 8 years, I've learned that the thing that I can do that is most helpful to him in his work is basically to just try to stay out of his way. And so I'm going to do that now. But as Chairman Bryan said, he's asked me to introduce Dr. Ricoeur to the group. And so I will do that now. Dr. Ricoeur's development as a clinical innovator and advocate has been shaped by a diverse career path that includes distinguished service in the United States Marine Corps. After earning his Bachelor of Science in Computer Science from Tulane University in 2001, Dr. Ricoeur served with honor as a commissioned officer in the Marine Corps, demonstrating leadership in roles such as Rifle Platoon Commander and Logistics Officer. His military service culminated in a deployment to Fallujah, Iraq in 2004 with 2nd Reconnaissance Battalion, where he received commendations for meritorious service and leadership, including 2 Navy and Marine Corps Achievement Medals. Following his military career, Dr. Ricoeur transitioned to medicine, earning his Doctor of Medicine from the University of Mississippi Medical School in 2011. He continued his medical training with a general psychiatry residency at Duke University Medical Center, where he was recognized for his academic achievements and leadership potential. Dr. Ricoeur pursued specialized training in forensic psychiatry through a fellowship at the University of North Carolina Medical Center, completing that training in 2016. Currently, Dr. Ricoeur serves as the medical director for the Mississippi Department of Mental Health, where he provides strategic oversight and clinical leadership across the state's behavioral health and intellectual developmental delay services. His previous roles include pivotal positions such as DMH Forensic Services Director, during which he spearheaded initiatives to enhance forensic mental health care and expand treatment facilities for forensic patients in Mississippi. Dr. Ricoeur's career is characterized by a commitment to excellence in clinical care, advocacy for mental health reform, and a steadfast dedication to improving the lives of individuals involved in the criminal justice system. So I'm happy to present to you Dr. Tom Ricoeur.
Well, thank you, Senator Bryan, for having me. It's good to see you all. I'm going to make sure this works properly. Okay, good. Okay, so today I'm going to attempt to go through everything you need to know about public mental health in 20 minutes or less. I'd like for you to stop me if at any time I say something that's confusing or problematic or needs some clarification. So every state is stuck in some form of litigation quagmire when it comes to offering public mental health. Most often these days, I know the Mississippi was had to endure an Olmstead lawsuit, but most of the times in states, there are issues with forensic public mental health. One in particular I'd like to point out is up in the right-hand corner. It's mentioning, there's an article mentioning Washington State, who has been enduring litigation for the last 10 years and has spent about $2 billion in remedy and litigation costs with no end in sight. Is there a strategy, a way to hold my hand? Okay. So this is a proper way to think about how public mental health services are offered. It's easy to get caught up in thinking about mental health just globally, but we want to be a little bit more specific. So just like in the medical model, self-care involves proper diet, nutrition, exercise, and then we go see our primary care physician when we start having something that's bothering us more than we can handle ourselves. And then if we're in a terrible car accident, we might be in the neuro ICU. That would be the top of this pyramid and is the most expensive and most scarce resource. In the same way, public mental health, self-care from a mental health standpoint happens at the bottom. As we get higher, we think of primary care physicians prescribing medications for patients, individual therapists in the community offering services, and then as we increase the acuity and the requirement for resources, you'd think of in that next to the top bracket, things like community mental health centers. And then at the top level, you want to be thinking about things like DMH resources. So these are, can I scoot this way so I can point? Good. Okay. So these three domains are where the state runs the risk of being sued, but these are also locations in which a forensic patient could be ordered to some sort of forensic mental health service. I'll show you how that works. Each of you should have been provided a handout so you can see how it works as well. So if an individual is facing a criminal charge and there's a possible mental health problem, a judge can order an evaluation of their competency. Competency has nothing to do with their mental state at the time of an offense. It has everything to do with their ability to work with their lawyer with a reasonable degree of rational understanding in the preparation of their defense. This wasn't a decision that the mental health folks made. This is a 1960 United States Supreme Court decision. Every defendant has to be competent to proceed legally. This front piece really only requires that the state recruits or attracts clinicians, so that means licensed psychologists or psychiatrists, to do these evaluations to determine whether an individual can proceed legally. If a person's competent to proceed legally, they're adjudicated. If they're determined not to be competent by usually a circuit court, they're sent for competence restoration. The points of litigation are, number one, states failing to get initial evaluations done quickly enough. Two, people getting admitted to the hospital for the purpose of competence restoration. Disambiguation is important here. When we're talking about someone who's accused of a felony offense getting treatment, that can be treatment in the jail. That can have nothing to do with this. Treatment, as it's described here, is treatment for the purpose of restoring a person's competence to proceed legally so they can enter the criminal justice system. That's the purpose of competence restoration. So it's important not to conflate people getting treatment in jail where they should be receiving treatment if they need it and treatment for the purpose of competence restoration. The last piece that House Bill 1088 addressed last year, and I'll get into the legislation piece in a second, is what happens to folks when they need civil commitment because they're not restorable. So a defendant who can never be restored to competence, it doesn't matter if the charge is as simple assault on a law officer, or if the charge is something more serious like capital murder. That person not restored to competence cannot be adjudicated, can never plead insanity if that's part of it, and is civilly committed to a DMH resource. That's something that I think a lot of folks aren't aware of, and it's useful to think about when you're talking about where the Department of Mental Health can be most helpful in keeping our community safe and providing services to folks. Okay, I think this is something that Senator Bryan wanted me to discuss with the group. In 2019, 2020, with brute force by the Forensic Evaluation Service at Whitfield, no person was waiting more than 30 days for an initial evaluation of competence in Mississippi, which is something that we had never seen. We had seen wait times of 1,000 days in some cases, and we got every evaluation under 30. And so then we got a tidal wave, no good deed goes unpunished. So we got a tidal wave of new evaluations, and we had to devise a way to get that solved. We started that with about 4 or 5 folks that could do evaluations in the state, and then we advertised for full-time positions at state hospital to do evaluations. Any ideas how many applicants we got for that? Zero applicants, 0 people reached out about it. And so we were sort of stuck. So it occurred to me that if we made this attractive enough, the Forensic Mental Health Act of 2019 required that we certified evaluators. If we made our process attractive enough and we created a website that increased transparency, maybe folks would come and get licensed in Mississippi to become certified evaluators. So any ideas how many we got for that? About 16. There's 16 people who got licensed in Mississippi from Tulane and Colorado and New York and are now certified evaluators in Mississippi doing these evaluations for the state. This website, so previously, I'm going to return. I know I can make this work. Okay. This can be a legal strategy. So if I'm looking for a way to delay my case, and I'm a defense attorney, attorneys always tell the truth, but sometimes they would say, I need an evaluation of competence, and that could delay the case, which can be helpful to them. And then they go to the judge. We're going in the wrong direction now. Okay, we're back. I'll just take what I can get. Go one more. Go one more. Nope, back. Okay. The one with the website. Can we do that? Back one more. Back one. That's good. Thank you. So they would say to the judge, Judge, I can't help it if Whitfield won't do their job. We don't know what's going on with the evaluation. Now, when we receive an order, we send a forensic ID number, and this tracks, and we send that forensic ID number to the judge, the administrator, the clerk, the defense attorney, and the prosecutor, and the sheriff with no patient information. So anyone in that system can look up the status real time of any evaluation that's taking place. So you can't then say, Judge, I don't know, Whitfield won't do their job, because this is shining a light on exactly what's happening in the system. And I think Senator Bryan was impressed with the cost. Any guesses on how much this cost us to put together? It's $13,000. Cost $13,000 to put together, and it's tens of thousands of views now, and the courts are actually using it. This is just an example of how we're attempting to use the available resources and the state law as it exists to solve problems that Mississippi has that are specific to Mississippi. By the way, other states, including Louisiana and others, have reached out about how they can do something like this to increase transparency in their state. Okay, perfect. This slide demonstrates everything you need to know about public mental health in Mississippi in less than 2 minutes. So this is the way a person, this left-hand side that I just discussed for forensics, is the way a person comes into the forensic mental health system. The overlap, you can see this pink outline on the far right, civil commitment, intersects with the provisions of House Bill 1640, because those are the same resources that need to be used for people who need civil commitment. So there's not a separate pot of beds for the extremely high risk mentally ill offender who's too mentally ill to ever go to trial. Those resources are the same. We have to use inpatient acute psychiatric beds, and folks occupy that space. Now, I have heard arguments made that maybe that's not what those resources should be used for, except there really is no place for these folks to go. Sheriffs have been sued over this, especially with the high-risk folks. People have waited in jail for 5, 10 years, having never been adjudicated guilty of a crime. We have to land a place for these folks to go. Good. 2019, the Forensic Mental Health Act of 2019. I just want to unpack these 3 pieces of legislation. There's a requirement that when a person is not restorable to competence on a felony charge, we notify the DA, who notifies the victim and sheriff, when we discharge a person. That prevents DMH from releasing someone prematurely without the knowledge of the people who keep our communities safe in law enforcement. Number 2, House Bill 1640, passed just this past year, makes it difficult for counties to hold mentally ill, not criminally involved individuals in jail. And I'm sure you've heard from Wendy, who said it's very clear in this particular case that this is reducing dependence on state hospital, which means we have increased access for folks who are not restorable to land in beds and be properly secured. And the last piece, House Bill 1088, there was a gap previously. Before last year, there was a requirement that a circuit judge remand a charge and send a case to Chancery for a person to be civilly committed. So the case left the jurisdiction of the circuit court, and the Chancery was supposed to pick it up. Often that ball was dropped, frankly, and we've seen regular cases of people who have been committed by a circuit judge, House Bill 1088, who have been years in jail between the circuit and Chancery court. So now we're regularly getting those folks in a matter of a couple weeks, and they can be dispositioned and get the treatment that they need. I want to point out here, today I'm going to be talking about the 4 state hospitals, best use of these 4 state hospitals' inpatient beds, but I'm also happy to talk about any of this if folks have questions as we wrap up. Okay, so these are the total staff DMH adult beds. You'll notice at the top, 25 maximum. Those 25 beds have historically been used for pretrial competence restoration. So these are our highest risk folks. They're still facing charges. They're in a hospital, but also require, for obvious reasons, a higher degree of security than you would get on an inpatient psychiatric unit. The new building you've been hearing about takes those 25 beds that have padlocked doors and no fire suppression and was built in 1955. It takes that number from, frankly, inadequate space to 81 maximum security building, 81 bed maximum security building to get those folks that are pretrial into the treatment they need. We also have 300 medium acute beds, 75 medium long-term beds, and 56 what we'd call supervised transitional beds. And it's easy to think that all of these beds are for just inpatient treatment, but there's another data point that I think is exceptionally useful, and it's in the upper right-hand corner. So when I talk about people landing in medium security long-term beds, some of the supervised transitional beds, and the maximum security beds, when we think about people who are not restorable or involved in the forensic system, and I look at that total number of 102, 49% of them have killed at least one person, right? So I'm not saying we're making Mississippi communities safer by holding on to people that broke into your neighbor's shed and stole an old microwave. These are the charges we're talking about, and this is part of our role in DMH in making your community safer places to live. By the way, this is what the sheriffs have asked of us, right? In terms of how we think about our role and our role as stakeholders, working with law enforcement, working with folks that provide care to these individuals who get sent to us. This is how I think we get this right. Currently, About 25% of the dedicated inpatient beds in the Department of Mental Health go to this population of not restorable, continued treatment, or forensic folks. Just memorize this real quick. This is our forensic level system. If a person broke into a neighbor's shed and stole an old microwave, they would be level 4. Those people, especially when they've already been incarcerated for an unreasonable amount of time, would go directly back to the community with community supports, and the highest risk folks would have several more steps before they would be possibly eligible to return to the community. So I won't belabor any of this. I do think there's a role to think about Department of Mental Health as a resource for both reducing suffering where it exists in the form of mental illness in the state, and thinking about ourselves as stakeholders in making communities safer places to live. When we incapacitate someone, I don't mean to connote physically preventing them, but I do mean preventing them from leaving, preventing them from returning to the community that they came from. We incapacitate them, and none of that for us is punishment, and none of it's for retribution in the way it can be viewed in the criminal justice system. We have to, by law, but we would anyway, focus on safety, dignity, and rehabilitation. And that's the intent of all of these new programs. It's also the intent of us having the ability to do that on the new maximum security building. This is a Venn diagram. These are our core values. There's several more on our website, but especially for forensics, if it's dignified and inexpensive, then it may be dangerous. And if it's inexpensive and safe, then it may be cruel. And if it's just dignified and safe, then it may be too expensive. But if it's all three, then we just do it. That's how we decide how to move forward. We make decisions with these primary values in mind. And if it meets all three of these and it's useful, this is how we engage. We've already discussed this convention. These are all of the organizations that we collaborate with on how to design our policies and how we interact with the community. Folks that are typically thought of as more conservative leaning, like our law enforcement agencies, and folks like MacArthur Justice Center, who instead of suing the state of Mississippi, found $750,000 in grant money and started a forensic navigator program to help get low-level offenders out of jail and into the treatment they need to reduce recidivism. So Mississippi is really experiencing something that no other state is experiencing, which is instead of litigation that has us mired in mess for the next 10 years, we just go ahead and start figuring out how we treat folks. And I think this is a paradigm that every other state wishes they could have too. And so I say all that to say, I think within the next year, we can set the standard. The Department of Mental Health in Mississippi can set the standard for how public mental health is done properly. The successes we've had, the certified evaluators, other states seeking consultation, MacArthur Navigators nationally recognized. With all your help, we've got this new maximum security building that'll be staffed shortly. We've got a residency program at State Hospital, all of these things. The threats to this are possibly every so often, there's a law proposed that allows pretrial defendants to be treated at a DMH facility. In other words, someone who's pending felony charges, which can take a long time in Mississippi, admittedly, if a law were to be passed that said those folks could be treated on the inpatient psychiatric service at one of the state hospitals, any defense attorney with half a brain would say, I want my client out of jail and in the state hospital. And they would be taking the place of a person who's in the community or a person who needs to get out of jail and into treatment. They would be taking that person's place. And what the DMH facilities would turn into are de facto jails. There's ways to get that done that doesn't involve current DMH resources, but that's a conversation for another day. One of the things that can happen is over advocacy. So sometimes you'll hear voices say, everyone needs to be out of jail and into treatment, except that to the extent that there are folks in jail who have antisocial traits, when you admit a person like that to a psychiatric unit, who do you think they predate upon? Right. So this is something that we occasionally see, a hope that we get a person who's got a personality disorder or serious behavior problems out of jail and into a treatment facility where there's victims abound. And so I think we have to be careful with that too. I think that's enough. All right. We're setting the standard in national public mental health care. And I want to make myself available now for any questions that anyone has about any of this, because that's a lot. Yes, sir, please. Oh, sorry.
Thank you, Mr. Chairman, and for your presentation. I know you said that this was a conversation for another day, but as it relates to the pretrial defendants and there being another mechanism to deal with that, I guess as briefly as you can you tell us what that other way is?
Yes, I love this question. So the first way is for someone who's charged with a low-level offense. Very often we have people referred to us who have already been incarcerated for 2 years on a charge with a maximum sentence of 5, let's say. That person, so I'll just as a specific example, let's say someone has a remote charge. So a long time ago, they were charged with some sexual offense and they're required to register. And they're homeless and they're mentally ill and they don't currently have any supports. And because they're homeless, they end up getting charged with a failure to register and they've been in jail for 2 years, let's say. So if they were found competent on the day they got admitted to our service, they'd be returned to jail to be adjudicated, and what would happen with them? Time served and released from jail back to the conditions that created the offense to begin with. So in cases like that, we've been asking the MacArthur navigators to say, reach out. I mean, in my experience in Mississippi, the sheriffs and the folks in the prosecutor's office are some of the most reasonable folks that I've interacted with. And when I point out this is something that's going on, almost universally, they want to do what's right for the person, prevent recidivism, and get this person where they need to go. And so in situations like that, one particular case happens relatively frequently, I would say a solution is remand the charge, send the person to civil commitment treatment, engage with a circuit court, refer that person to community services, so like assertive community treatment, I-Court, all of these available services that are already paid for, and that increases the probability that this person can get what they actually need instead of being sent through the criminal justice system. So it comes up relatively regularly that there's a person who has been in jail for an unreasonable amount of time prior to being sent to forensic services, and really what that person needs is, what they need most are supports that prevent them from having worse problems. Now, in the case of an extremely high risk, possibly mentally ill individual who's got behavior problems at the jail, this comes up pretty frequently because the jail is holding a person. There's a 14th Amendment issue on them getting the services they need while they're currently being held. So there's one way this could be addressed is to have a centralized location where mental health treatment is provided for folks who are not found to be incompetent, but are having a mental health crisis, for example. I worked in Central Prison in Raleigh, North Carolina, and there was a inpatient unit for counties to send folks to. There's strengths and weaknesses to that, but I hope that's helpful. We've been encouraging, I mean, this is the last thing I'll say, we've been encouraging folks in the criminal justice system, especially in cases where people are languishing in jail. If we can eliminate the charge, let's get this person into treatment so that they can get what they need. Does that answer your question? Okay. Okay. I can. Yes, sir. I do. And this speaks to the point that I was attempting to convey, maybe imperfectly, is that when a person is sent for a forensic service and their charges are still pending, then the interaction between what is offered in treatment and the purpose of treatment has to do with getting them ready to face their charges. But and this is, I think this has been the strength of the discussions I've had with folks in law enforcement, when instead we say there's no more legal charges. Those have gone away, and the person gets sent for civil commitment through Chancery Court. Then they do get wraparound services. They get connected with a community mental health center. There's supported employment. There's housing options. There's layers of ways that we can get folks who are homeless and that have had some of these issues into a situation that's better than the situation they came from, that reduces the probability of them getting in trouble again. So we do have that ability. And we've actually found that folks in the criminal justice system have been more than willing to work with us on finding resources for folks.
When you say folks in the criminal justice system, who are you talking about?
That's a great question. Let me be specific. Sheriffs have been remarkably helpful in this process. And if I call a defense attorney and I say, hey, look, there's a person who I think would be good for diversion that we could get into treatment instead of jail, of course, they're going to be cooperative, right? So what we're talking about is if I'm having a conversation with a prosecutor to say, hey, is there a, and frankly, at this point, we're asking MacArthur to help us with that. That's part of the collaboration. But the question is, what are we aimed at here? Is what you want retribution and punishment, or do you want us to aim this person at something that would actually be helpful to them? And this is something we review in every case that gets sent to us.
I'm just going to let Dr. Rekor recognize people at his discretion. So I should say, before we get to Senator Wiggins, you mentioned that you had found a number of cooperative people in the district attorney's offices.
Yes.
It may be because they find the difficult people and send them to the state legislature to get them out of. But anyway, Dr. Rekor, you could just recognize people yourself for this.
Please.
No comment. Doctor, you said as it pertains to 1088, when in light of the passage of that law,
Mhm.
that y'all started seeing folks who had been in jail for years.
Correct.
What was it about the system? I'm calling that a bottleneck.
Yes.
What was it about the system that created that bottleneck that we had to pass the law? And now those folks are coming to y'all for that.
That's perfect. So if we can go back to the map. Almost perfect. That's it. So at this point, at number 3, with folks are not restorable, right in the middle of the map. Previously, the law required circuit judges to remand a charge. So you can imagine someone's charged with a seriously violent offense, a murder. And their role here, the circuit judge's role, is to remand the charge, hands off, And then the circuit, the chancery judge in that county would pick it up and do the civil commitment. So there's a lot of steps when that happens. There's got to be faith that the chancery court's going to pick it up. The chancery court has to agree to pick it up at some point. So what we saw pretty regularly is judges in the circuit were hesitant to remand a charge, okay? But then when they did, the chancellor would say, we're not picking this up. And so the person would fall into this legal gap. And one of the things I heard from the judges regularly, the circuit judges, is we want to get this right. We want folks civilly committed. We want them in treatment. Can you help? And 1088 did that. So 1088 eliminated that bottleneck by allowing circuit judges to retain jurisdiction and enter a civil commitment on folks. I think we've seen a dozen so far. Folks and some of these, I mean, at least in one case, 4 years, the person had their charge remanded and they waited in jail. So
Why would the chancery side of it say we don't want to do it?
I don't know. I mean, this is forensic mental health itself is something that most clinicians are uncomfortable with. Unless you've had forensic training, then clinicians would be uncomfortable with it. And then chancellors were pretty comfortable in sort of the low-level cases, it seemed, but at the highest risk cases, a regular civil commitment, I think it was problematic. And let me own a couple of the flaws of the Department of Mental Health. In previous years, I think this has something to do with the medical director position, frankly, but folks have been released from civil commitment having had relatively recently killed somebody. And that person would return to jail and the sheriff would say, what am I supposed to do with this person? Because the process was gone through and now they're back at jail. Well, developing this continuum of care in all of those charts that I've shown you is our mechanism for addressing that issue. So when a person is extremely high risk, they get sent to us. We know about them. We have a mechanism to track them. And now folks who are in the criminal justice system, the circuit judges, and the chancellors for that matter, can rest assured that we're getting it right. So that's another part to it as well as public trust.
If I could interject at this point, I've been thinking as you've been talking, and one thing that occurs to me in this area and a bunch of others is we have a lot of problems in Mississippi. One of the things that we've got going for us, though, is that we're relative, in general terms, we're a bunch of small towns. People know each other. And so the population is small enough that interventions one by one are possible and also have an impact. The other thing that strikes me, and this is true in procurement, which we'll get to, I hope, before all this is over, there's a problem of silos and a problem of something being either everyone's responsibility or no one's responsibility, as the case may be. So having someone whose job it is to go around and find these people that seem to be in jail for very long periods of time and look at the situation one by one, and then there's this wonderful invention called the telephone. And you can pick it up. It's right there on your desk. You can pick it up and call somebody and have a conversation. I hear there's such a thing as hooking up several of them together. But I think a number of times there are problems which it seems to me could be resolved by a telephone call that get stuck in an endless situation of moving from A to B to C, and everything just gets frozen in the process. And so those are some of my answers to questions. I think if I'm not wrong, House Bill 1088 that we're talking about went through judiciary. And I think that I thought the provision about having circuit judges get involved in the civil commitment process when we already had inconsistencies going from chancellor to chancellor, just added another level of inconsistency. And so I voted wrong for that reason. I've been persuaded I was wrong about that.
Let the record
I
reflect.
figured you.
January 14th at 3:42 PM.
Oh, Senator Wiggins, I've got 40 years worth of being wrong about stuff. You know, there's plenty of that on the record. But I mean, seriously, I've come to see the wisdom of what we're doing. And I think also the comment, what's wrong with the chancellors don't want to get blamed and really don't know how to deal with someone who's killed somebody. Circuit judges, for better or worse, deal with people who've killed people. And so maybe that is the appropriate thing for this anyway.
We use that thing you were mentioning about picking the thing up. We use that, and that's been one of the ways that circuit judges, they reach out to us. We reach out and say, here's a person. They ask, how does this process go? We have all of the form orders available on the $13,000 website, and they access that so that everyone's speaking the same language. So.
Thank you, Dr. Record. On the $13,000 website, which is very impressive, through the bills we passed over the past few years, we've asked for data from community mental health centers, from chanceries, and it's been extremely inconsistent. And the reason we get is, well, everybody has a different system, but we're asking them all the same questions, but we're not getting the same answers, or getting them different formats. Has DMH, or could you look at a standardized way that we could receive data from these entities where we can make better decisions?
Yes,
Will you?
absolutely.
But you've seen the struggles. I mean, just last month, only 43%, I think, of the chanceries even turned in their data, and that's not acceptable.
Well, I think as we aim at better, whatever better is driven by data. And so if the question is, how do we get better? Well, it's data-driven decisions. And, you know, we work for the taxpayers of Mississippi, and we want their money to be of best use in making their communities safer places to live and getting folks the treatment they need. So looking for ways to standardize data, I think we'd probably need some help in accountability and as a Department of Mental Health, our ability to say to a county, you will give us this information is limited, but there may be ways that we can work with whoever needs us to work with them to identify ways to ensure that data is provided.
Well, it's not complicated, what we're asking. And I get the Department of Health has no real teeth to, well, if we don't turn in, what can DMH do to us? Nothing really. So
Right.
The legislature is willing to work with you to simplify this so we can receive the right information. Thank you.
Yes, sir.
To sort of follow up on all of that, and this is why I keep going on about this website that you have. Several months back, the coordinator of mental health produced a report saying that the information coming from community mental health centers is gibberish. That's my word, not his. But you looked at it and there was just no consistency. It was almost as though someone had put random numbers in, or indeed no numbers in. And so that's not right. So we had a hearing to sort of look into this. And basically, the community mental health centers thought they were being asked to report way too much data, to report the same thing more ways than one, but then they weren't using the same definitions when it came time to report X. So as a result of that, the community mental health centers and the Department of Mental Health have been having ongoing conversations, and they're working through some of those issues. However, we get, as it always seems, into the world of computers. And I learned, and somebody straightened me out if I hadn't got this exactly right. There's been a need to get computers for the community mental health centers. And there are many of them that just can't afford the amount of money that would be required to get what was needed. But ARPA comes along and there's like $50 million or something set aside for this. So a lot of money, a lot of zeros, more zeros than I have. And so it took a year to get language agreed upon between the community mental health centers, the Department of Mental Health, and ITS for an RFP. And then at that point, it said, well, it'll take us more than a year to get through the procurement process. And by the time all of that's done, we'll be up against the state deadline. So they gave the money back, which seemed to me disturbing on so many levels. So I called up someone over on the ITS board. What are y'all doing over there? And he said in so many words, it appears that what happens is an agency calls ITS, and the next ITS person in line takes that call. There's not an ITS person assigned to agencies like the AG assigns people to agencies. And then he says they tend to communicate by email, and emails don't always get answered. And so someone will have a question, they'll send an email. The email will sit there several days, then the answer will come, And so literally they've started using the telephone. Well, it sure seems to me that if I'm at random agency, I would have an ITS person or a technology person of some type, perhaps not an expert. And I would think that at ITS, there would be a higher level of expertise and familiarity with what had happened other places and times. And so again, they could pick up the telephone and talk, and in a collaborative method, work something out in a couple of weeks, which tends to take a year. And he said, yeah, we started using the telephone now. And heaven only knows about the procurement process and all the reviews. And then apparently we have designed a system where no matter what procurement steps you go through, there is a plausible argument that you didn't follow your own procedures. So there is a non-frivolous, in the Rule 11 sense, non-frivolous attack on the procurement process and a challenge to, and it just goes on and on and on to the point that I have said, I want to abolish the personnel board. I want to abolish ITS. I want to abolish all the bid laws, all the procurement laws, and just let any agency head who's got an appropriation spend any amount of money hiring anybody at any salary he or she wants to and buying whatever he or she wants to at any price. And if the agency head wants to say, well, if you wanted to do business with the state, you should have contributed to the governor's campaign. You didn't do that. Next, I don't care. Nothing could be worse than where we are now. And so I go out to Whitfield for this gathering that Chairman Creekmore and I went to, and by the way, I tried every way I could to make sure this was not an intervention that I was walking into. And so I get there and find out that for a cost of less than $15,000, you've procured a website, and this is not as difficult as what we wanted. It's not as comprehensive as the information we've been wanting to get from the community mental health centers and from the clerks and all that, but it's the same principle. And this got done for like $15,000 in like 15 weeks or something. So how is it that you're the only human being in all of state government who can actually get some software up and going?
I tried to get my administrative assistant to do it for $0. because he already worked and he said he could do some database programming, but it was a lie. And so we ended up having to go to an IT group and say, look, the information behind this requires a person to input it. So if she were not as competent as she is, it'd be garbage in, garbage out. So we've worked really hard to recruit competent, dedicated people that care about this strategic vision. And so then the data you get back, the judges can rely on, and the folks who are involved in the system can rely on it. And so, I don't know how we were able to get it done, but it turned out to be something that appeared low risk and high reward, and it's been more helpful than I even thought it would.
I just think you're going to get in trouble for doing this sort of thing.
I anticipate that. Yeah.
Did you go into detail or some detail about the new facility you have and the cost of it?
I did not go into costs, no.
But could you sort of describe the various levels and the design of the building and?
I'd be happy to. So this building, the building that that Senator Bryan's referring to is a renovation of a currently existing building at Mississippi State Hospital. It used to be a female receiving service. And after a couple years of consultation and meeting with experts on the topic, we designed something that suits perfectly this population we're hoping to be helpful to. There's 2 downstairs levels, 9 beds each. Each unit upstairs is also maximum security, individually locking rooms. Every room has natural light. It's painted in a tan, green, blue pastel color there's some evidence that these colors are helpful with agitation. There are holding rooms for people who need initial evaluations, and the certified evaluators can use these rooms. We even thought as much as to have, with individuals' consent, one-way mirrors and a mic'd up conference room, so that during an evaluation, we can have our psychiatric residents observe what's taking place to learn how to conduct these themselves. And so each of these steps, I would say that any person at any jail that's experiencing, that needs to come in for competence restoration could be served in this facility. But even within the continuum on the building itself, we've got a high level of security, and then each floor above is also a high level of security. So it's state of the art in its ability to provide security and to maintain the historic look of State Hospital, and to actually be rehabilitative for people who are sent to our care.
It just seemed to me that when I was there, it was an incredible combination of a building built to be functional for the purpose the building was intended to be used for, and also an extraordinarily rewarding combination of concern for safety and security, and at the same time, compassion for the poor souls that are in this condition in the first place. I don't have much to be happy about these days. I'm very happy to see the building. Do you have any?
Thank you, Senator.
Thank you for coming. Does anybody else have anything? If not, thank you, Dr. Ricord. We appreciate your coming.
Thank you.
Without objection, we'll adjourn.